Hello, everyone, and welcome to Esquired. This is your host, Amber Morris, and I am especially excited to bring you this episode regarding business interruption insurance in the wake of the pandemic. Today marks the first day Esquired is recording with a guest. Our guest today is Professor Christopher C. French. I was fortunate enough to take classes with Professor French throughout all 3 years of law school, and he has been an amazing resource in my academic and legal career. Professor French received his JD from Harvard Law School and worked in the commercial litigation department at a large multinational firm for over 20 years. While in practice, Professor French litigated insurance coverage claims on the policyholder side, representing companies involved in litigation with insurance companies. Professor French is now a professor of practice at Penn State Law, teaching courses like torts, contracts, trial advocacy, and of course, insurance law. He has written extensively on insurance issues and has even co-authored an insurance law casebook. You can find a link to some of his articles in the description of this episode. But before we begin, here's your daily disclaimer. The information provided on this podcast does not and is not intended to constitute legal advice. All information, content, and materials available on this podcast are for general informational purposes only. Information on this podcast may not constitute the most up-to-date legal or other information. Use of and access to this podcast or any of the links or resources contained within do not create an attorney-client relationship between the listeners and podcast contributors. This includes contributing law firms or guest podcasters. Listeners of this podcast should contact an attorney to obtain advice with respect to any particular legal matter. No listener of this podcast should act or refrain from acting on the basis of information on this podcast without first seeking legal advice from counsel in the relevant jurisdiction. This podcast contains references to third parties. Such references are only for the convenience of the listener. Esquired LLC and its members do not recommend or endorse the contents of the third parties. Okay, and without further ado, here's Professor Chris French. So we are on. Thank you for coming. I appreciate you taking the time to talk to us today, Professor French. Before we begin, can you kind of just describe what you did in practice?
Sure. It's always a pleasure, Amber, to get the gap together with you, one of my prized students over the years. So I'm happy to spend some time with you today. So as far as my background goes, I was a commercial litigator at a big law firm. We were headquartered in Pittsburgh. That's where my office was too. But the firm now has offices all around the world. I'd say at least 20 or 30 offices at this point. But big law firms like mine, we tended to focus on commercial litigation between other companies. It's usually big companies suing other big companies. And my particular specialty that sort of developed over the years was suing insurance companies, usually on behalf of big American corporations like DuPont. For Pittsburgh, Alcoa is another big name here. PPG is another big Pittsburgh company that we did a lot of work for. So my practice, even though I started off doing general commercial litigation, which included just regular breach of contract and non-compete suits, all that. By the time I retired, which was roughly 8 or 9 years ago, I pretty much was only doing insurance coverage work, suing insurance companies on behalf of other big companies. Sometimes they were smaller companies, but typically they were big companies. And one of the interesting things about the way we approach these lawsuits is that we typically would sue many insurance companies at the same time, because big businesses often have multiple layers and multiple years of coverage that may potentially cover claims. And so we would they'd almost look like class actions because we sued that many defendants in those lawsuits. But they were, some of them were really big and some of them were just big, in size.
And as you mentioned, I took you in law school. I've been saying for the past 3 years, you've been cold calling me, and now it's my turn.
Yeah. Well, I think I'm up for the challenge.
I think you'll be fine. So when you were doing these insurance claims, what kind of stuff did you see? Asbestos, CERCLA? Can you kind of describe what those are?
Yeah, it was a full spectrum, but those are two of the big ones. CERCLA was basically the environmental statutes that were passed in the 80s that required people who disposed of waste and people who hauled it or the generators of the waste were all basically strictly liable for the environmental pollution and contamination they caused. So CERCLA allowed the government and private parties to sue to get cleanups. And so we did a lot of work on behalf of companies who had been required by the government to clean up waste sites and their own plants and stuff. They turned around and tried to get their insurance companies to pay. So we did a lot of that work. So that's what CERCLA was the shorthand acronym for those statutes that allowed the government to do that. On the product side, asbestos, as you mentioned, was a big issue in those days. It still is to some extent now, because you still see the people on TV advertising, personal injury lawyers advertising for mesothelioma claims and stuff. That's just a subset of the asbestos litigation. The same situation, we had clients, we didn't really represent a lot of the manufacturers of asbestos products. We tended to represent companies that use asbestos products at their plants and stuff. They then get sued by people who came on their plants and claim that they were exposed to asbestos while they're at their plants. And then we turn around, we pay those people their claims, or at least some portion of it. They typically would sue dozens of companies. Our clients would pay some portion of their liabilities. And then we turn around and sue insurance companies to get them to reimburse us for those liabilities. But those are the big ones. I mean, there were lots of other weird areas of insurance that we did too. Like I had this residual value case where we represented a bank who actually leased automobiles directly to consumers. And at the end of the lease terms, they would sell the cars. And if they couldn't sell them for what the projected value was before they leased them, they had insurance to cover the difference. And those numbers could add up if you were in a recession. And so, we had weird cases like that too. We also had machinery and boiler cases where companies have insurance plans that cover the breakdown of equipment that's needed to run their businesses. So there's pretty much anything you can imagine being insured is insurable. And there's somebody out there who will insure it. Oftentimes the really strange ones, you're looking at Lloyd's of London, but there's usually an insurer that will insure about any type of risk that you can think of.
Right. And so today we're going to be talking about business interruption insurance, as you know. Before we get into the nuts and bolts of that, could you just describe what kind of classes you teach too? So now that you're not in practice anymore and you're teaching at Penn State Law, what kind of classes do you teach? And, do you teach this kind of material in those classes?
Yeah, so I teach a wide variety of subjects at the law school and other law schools before I came to Penn State. But I teach a lot of what are the sort of the core 1L classes for the first year law students, things like torts and contracts. And what's relevant to this particular discussion today is the insurance coverage. So I teach the insurance law class at Penn State, and I've taught that even back before I became a law professor. I was teaching that when I was in practice as an adjunct at Duquesne. But yeah, so insurance coverage, we cover a lot of different topics, but business interruption is one of the subjects we cover. I have a casebook I've written that I'm using now in my class, and I have a segment in that casebook on business interruption insurance. It's an area of the law that even insurance lawyers don't know a lot about, most of them, because it's such a niche area. In fact, we're going to learn more about business interruption insurance over the next year because of the COVID-19 claims than anybody probably listening to this podcast knew about before this stuff came up. So, business interruption insurance was an area that I did 2 or 3 trials on right before I retired. One was for equipment failure. Another one was from flooding that caused these business interruptions. So tornadoes often cause them. So we'll talk more about that in a minute, I'm sure. But so I had 2 or 3 cases like this right before I retired that I did. And then I ended up sort of working those materials into my casebook, and I teach it at the law school.
So what exactly is business interruption insurance?
In a nutshell, it's just insurance that's designed to cover a business's revenue stream when they're shut down for some reason. So, a tornado comes and rips the roof off of their plant or their restaurant, and they have to put a new roof on. The time period between when their property is damaged and when they get their business running again is the interruption period. And so they get their revenue stream covered during that time period. It's designed so they can keep their employees employed, so you don't have to lay off your staff because you have a revenue stream coming in. You can keep paying your employees, allows you to pay your taxes and insurance and rent and stuff like that while you're trying to get your business back up and going again. It's part of property insurance. So when you buy commercial property insurance, some policies include it automatically, this business interruption coverage. Oftentimes, though, you have to buy as an add-on coverage. It's like a separate essential coverage that you can buy. And so small businesses in America, roughly 40% of them have business interruption insurance that they bought along with their property insurance. Bigger companies, large companies like the ones I typically represented, they usually have it, all of them, almost all of them buy it. But it's basically just designed to cover your revenue stream while your business is damaged and while you're trying to get up and running again after you've been hit by a catastrophe, flooding, hurricanes, tornadoes. Those are sort of the common ones. 9/11 would be another one that comes to mind. Things that shut you down.
And how big, you mentioned 9/11. We've also seen this in Hurricane Katrina, some disasters that have occurred, how big are these claims typically?
It depends on how localized the catastrophe is, right? So tornadoes tend to cut swaths through America, narrow paths, but anything they hit in their path is going to be shut down if it's a severe tornado. So that's a smaller scale. Hurricanes like Katrina and stuff, where they took out, obviously all New Orleans, but there's lots of other parts of the country that got shut down because of Hurricane Katrina. And hurricanes every year are shutting down business. So the hurricane side of this is huge. The flooding side of it is huge as well. One problem with flooding, though, is a lot of property policies don't cover floods. So I wouldn't say it's an exception rather than the rule, but it's not as common to have business interruption coverage covering flood. I did have a client that did, but that's not the norm. Mm-hmm. Flooding is typically excluded from coverage under both homeowners policies and under property policies for commercial entities.
And one thing that we can kind of get into the nuts and bolts of now is the physical loss. So can you kind of explain what physical loss in business interruption means and how that would be proven by the policyholder?
Yeah, so that's obviously the biggest issue, I think, right? Well, there's one of two of the biggest issues related to COVID-19 claims, but these are property policies. That's what people have to keep in mind. The business interruption coverage is part of a property insurance policy. So you have to suffer some type of property damage in order to trigger coverage, even for business interruption. It doesn't necessarily have to be to your own property. If you buy contingent business interruption coverage, you can buy coverage so if one of your suppliers' business is damaged and they can't supply you anymore, you get coverage for that loss of the materials you need. Similarly, if you have customers who buy from you, like say they buy a lot of your services or goods, and they can't buy from you because they've suffered property damage, then you could get coverage under that contingent business interruption coverage. But under all of these coverages, so because there are property policies, you have to show there's been some sort of physical loss or damage to property that's causing your business interruption. And that's where the fight's going to be in the COVID-19 stuff about whether or not these government ordered shutdowns qualify as physical loss or damage. There's a whole bunch of cases out there, and this is the insurance industry's position, that physical loss or damage, that phrase, which is sort of the key language in these policies, means tangible physical damage. So you have to have the roof torn off, for example. But there is another set of case law out there, case law meaning court decisions, and that's where the law comes from, where they've held that basically the inability to use your property due to something unsafe about it can trigger that physical loss or damage phrase. And so I'm assuming the policyholder is going to be pushing that line of cases on the court, saying, look, there's been cases out there where they had E. coli contamination of the wells. That constitutes physical loss or damage to the property, even though the well's not on the same premises as the property, because they can't use the property without water. The water is contaminated, so therefore they've had a physical loss or damage that's triggering coverage. So there's a bunch of cases like that. Asbestos is another context where they found asbestos in buildings, so you can't occupy the building until the asbestos is remediated. That's been found by courts that constitute physical loss or damage to that building. So that's what the phrase is about, and that's why it's going to be important. The policyholders have to prove that there's been some physical injury or physical loss that's preventing them from running their business. And here it's going to be, the argument's going to be that the government ordered shutdowns because of the danger of COVID-19. If your business is open, it's unsafe because people may be in your business that have COVID-19 exposure and contamination, even though they don't show any symptoms. You don't know that they're sick, but you can't be open because they might be, because it's creating this unsafe conditions for your customers and your employees.
Right. So I was doing a little bit of research too, and what I think you were talking about was the kind of uninhabitability of the premises.
Exactly.
Right. Yeah.
Uninhabitability. They also some of the cases also talk about rendering the property useless for its intended purpose. Mm-hmm. So usually it ties into the uninhabitability of it, but sometimes the uselessness can be a factor as well. And so the contaminated water is another circumstance like that. The building is perfectly safe to be in, but if you can't use the building without the water, it makes the building useless. So therefore you would satisfy the physical loss or damage trigger.
So what are we seeing right now with the pandemic? There's obviously the issue of the actual disease being in the premises or around the premises. Can you also talk about the government order? I mean, you can talk about both, obviously, but if you could also talk about how these government orders and stay-at-home orders could affect this type of coverage?
Yeah, I mean, if, like in Pennsylvania, for example, the governor, even in the order, when he shut down the businesses, he used the phrase that there was physical damage, physical property damage occurring at these businesses, like restaurants and hair salons and that kind of stuff. He didn't cite anything specifically to support that, but it's in the order itself. And so policyholders are going to argue that the governor's declared physical property damage at their premises in the presence, either in the presence of COVID-19 or the risk of COVID-19 getting there. So you're seeing that in the wording sometimes in some of the orders, but if it's not specifically in the order like that, the argument is basically that the reason the government orders are shutting businesses down is because the properties are unsafe. So that's how they're going to try to claim that there's an uninhabitability, it's unsafe to occupy, therefore you should trigger coverage. The other argument that you mentioned, though, the insurers are not too persuaded by either, is that some businesses actually can show they have contamination in them. Think about that cruise ship where they tested it over 2 weeks after the people had evacuated the boat. They still showed the presence of COVID-19 in the cabins and stuff 2 weeks later. In that circumstance, it'd be pretty easy to argue that you got contamination of COVID-19 in your business, therefore that constitutes physical loss or damage. Insurers say no to that because they view that as just a temporary situation. They say all you have to do is come in and spray it and wipe it down. So therefore, if you're out of business at all, it's only for 10 minutes or 2 hours, how long it takes to clean your business. So yeah, we'll pay you for the 2 hours, but that's not really worth fighting about. Mm-hmm. So that's the other argument, one that the actual presence of contamination versus the risk of contamination.
So I also have seen arguments from insurers about the actual insurability of a pandemic. And I can direct listeners to, I have an Introduction to Insurance series that they can listen to where I talk about insurable risk, but basically insurable risk, something has to be insurable. It needs to be able to be paid and covered. So can you kind of talk about the insurers' arguments about how this isn't even an insurable risk?
Yeah, so you've seen the CEO of a major insurance company, who I won't name right now, but he's been quoted in a number of media outlets basically saying, pandemics are uninsurable. We didn't charge premiums for this. We couldn't charge enough premiums to cover this, even if we wanted to, that if we had to pay all these claims, it's going to bankrupt the property insurance industry because the losses are so much more than our whole net worth of the whole insurance industry that we couldn't cover it possibly. So, but what you're talking about, how the background of that argument they're making is that for a risk of being insurable, they say we have to be able to know how many claims we're going to have in any given time period and how much we're going to have to pay on them. And so things like life insurance and auto insurance are pretty easy to predict because they have a whole lot of data of people driving for years and years. Life insurance, they have actuarial tables, and they can tell if you smoke and how old you are. They can predict how long you're going to live, so they're going to know how much to charge. They say for things like pandemics and other uninsurable risks like flooding, they claim is uninsurable. Well, some of them say that, but then at the same token, you'll find some private insurers do insure floods. So some of them say it's uninsurable, others nonetheless insure it. But the idea is they have to be able to have enough data to predict when and where these events are going to occur and how much to charge to cover their losses. And they're saying pandemics occur everywhere, worldwide at the same time. So we couldn't possibly charge enough to cover all those losses. And so therefore we view it as uninsurable. If we can't predict the losses and how much they're going to be, we can't charge appropriate premiums for, therefore we view them as uninsurable. And frankly, natural catastrophes as a whole, many insurers put into that bucket. Earthquakes, flooding, landslides, things that happen, wide scale losses at the same time at the same place, they view as uninsurable because they can't predict them accurately enough. That's certainly their argument. But there is a lot of evidence to refute that argument too, though. I mean, I gave you the flood example. You find some private insurers do sell coverage for flood. On the commercial side, it's not unusual at all to have commercial policies that cover flood. Although, like I said, some insurers do, some don't, but it's not uncommon. But even in the pandemic context, this COVID-19 context, there's several insurance companies right now selling pandemic insurance. Marsh, which is a large broker, has got together with an insurance company to sell a product they call Pathogenics, which is basically designed to cover pandemics. Wimbledon was canceled this year. They had insurance to cover the cancellation of their event due to a pandemic. They started buying this stuff after the SARS outbreak in the early 2000s. I understand the British Open has similar insurance, and they're going to be covered for the canceling the British Open this year. So even though the insurance industry is claiming that pandemics are uninsurable, there are some insurance companies selling insurance to specifically cover just pandemics. So it's not clear to me that they're correct. What they may be really trying to argue is that we can't cover pandemics under just generic all risk insurance. And so we can sell it to you on a specific line of insurance, specifying specific types of pandemics we might cover. So for example, one of them covers Ebola outbreaks, but that's a very specific type of virus. They think they've got their hands around how it occurs and how quickly it'll spread, that kind of stuff. In general, they don't want to cover pandemics just as a group though, because they think it's too unpredictable.
Right. It's like cyber insurance, where cyber insurance typically isn't, grouped with the all risk meaning like covering a host of things. It's more a specific line, or even an endorsement. I mean, have you seen any endorsements on policies with pandemics?
No, I have not. No. I've seen sort of the flip side of that. I've seen all risk policies that have endorsements adding virus exclusions.
Okay.
See, that's one of the issues, is that some of these policies have a virus exclusion, some of them don't. And so the general argument is that these property policies are all risk policies. They cover all risk unless it's expressly excluded. Then they add these exclusions for earthquakes and flooding, that kind of stuff. The argument is if they don't have a virus exclusion, that means the viruses must be covered because it covers all risks. And they say, the fact you guys do have virus exclusions means you know how to put it in the policy if you want to, and if you don't put it in, it must mean you tended to cover it. So that's sort of the flip side of the argument.
And for those that don't know, typically when the language is ambiguous, the policyholder will come out on top if they can, prove that the language was indeed ambiguous.
Yeah, and that just means they have to have a reasonable interpretation, even if it's different from the insurers. And it doesn't mean that they have to have the best interpretation. It just has to be reasonable. So right. If the insured party, the policyholder here, has a reasonable interpretation that there's coverage, then there is coverage. That's just the default rules and how you interpret insurance policies.
Right. So if you had to boil it down to one or two arguments, what would you say is the best argument for the policyholders, and what do you say is the best argument for the insurers with regard to this pandemic?
Yeah, so let's take it in reverse, starting with the insurers, because their position is much shorter in the sense that they say all policies are unambiguous, completely clear. They don't cover pandemics because they don't qualify as physical loss or damage. They're saying the pandemics are not physical loss or damage, therefore you don't even satisfy the insurance agreement language in our policies. Then they say, by the way, even if you could satisfy that insurance agreement language, which you don't think you can, we have this virus exclusion in a lot of the policies. And they say it's, specifically is intended to cover the SARS virus. I mean, SARS is specifically referenced in our application for this exclusion. Back 14, 15 years ago when we had this approved, we specifically referenced the SARS virus, which is, what COVID-19 is based on. So we have this exclusion that takes coverage away. And then their third argument is sort of the public policy argument, which is that, you're going to bankrupt us if we have to pay for this stuff. We didn't intend to pay for it. We didn't intend to cover it. We didn't collect premiums for it. And we're going to be bankrupted if we have to pay. So that's sort of the insurance company's argument in a nutshell. The policyholders, on the other hand, they have a little more nuanced argument. They have that body of case law I mentioned earlier about whether or not the lack of inhabitability of property or its uselessness of the property because of some condition qualifies as physical loss or damage. So they're going to push for that. They're also going to argue the argument I just made a minute ago, which is that if our policy doesn't happen to have a virus exclusion, that means it's covered because they would have added a virus exclusion if they intended to exclude it. Since they didn't, it's covered. The third argument I think that the policyholders will make is this whole argument designed to address this argument that pandemics are uninsurable. They're going to say just what I said a minute ago, which is that, well, they sell insurance that covers pandemics. Wimbledon, the British Open, Marsh's product line, there's another company selling it as well. If it's uninsurable, then how can these insurance companies actually be doing it? And then I think the last argument that policyholders will make is sort of the public policy argument. And whether or not there's any traction with this argument is going to depend a lot on what state you're presenting these arguments to, what the courts look like in that particular state. But the argument is going to be, look, insurance is intended to cover this kind of situation. If insurance is not intended to cover catastrophes like this, what really is it intended to cover? If our business shut down, we bought business interruption insurance. We thought that meant we were covered when our business shut down. Insurance is supposed to serve as a social safety net that we're paying for ourselves instead of taxpayers. And we paid premiums in all this time. The insurance should step up when it's time to be paid, kind of be called upon asking to pay. Mm-hmm. They'll also point to the fact that public policy underlying insurance is to make sure injured parties are compensated. That's the whole reason auto insurance is mandatory. They're not worried about you having insurance coverage to cover your car when you crash it. They're worried about making sure you have insurance to cover the people you hit in their cars. And so the big public policy underlying insurance is to compensate injured parties. Here we have hundreds and hundreds of businesses that have been shut down for 8 to 10 weeks at this point. And there's a public policy favoring compensating them, and we use insurance as that vehicle to do that. So I think you're going to see those arguments being presented. And then you're also going to hear sort of the general fairness argument, which is that we've been paying premiums for years. Insurance companies collected those premiums. It's time for them to honor their end of the deal. And if they don't, then you're basically telling us our policy, our contract is not enforceable. And there's a public policy favoring the enforcement of contracts. Insurers, by the way, will make the same argument on the flip side. They'll say, our contracts say this stuff isn't covered. You should enforce the wording of it. So I think both sides are going to make that same argument about the enforceability of contracts.
Do you have a probable outcome? Do you think that a majority of jurisdictions will go one way, a minority will go another, or do you think it's kind of going to be split down the middle? What do you think is going to happen?
Well, it's interesting because there's been over 100 lawsuits filed at this point. A lot of them have been filed in federal court. There's been a bunch of them in state court as well. And many of them have been filed as class actions. And I haven't spoke to the lawyers who brought these actions, particularly the class actions, to figure out what their strategy is, but I can sort of guess. But they're bringing us class actions so they can increase the pot. They want to have as many claimants in the cases as they can, which will drive up the settlement value of the case. Ultimately, if they had to go to trial, the trial value, which in turn will drive up the fees they collect. And they filed them in federal court, I'm guessing, so they could get around the state jurisdiction problems you would have if you filed it in state court. The problem I see with this, though, just from not knowing their strategy, from just looking at the list of places where these lawsuits have been brought, is that federal court in general is not as friendly a jurisdiction to be in if you're a claimant. You'd rather be in state court for most types of claims. And so by presenting these lawsuits in federal courts, and in a lot of them are in New York, for example, which is the least policyholder claimant-friendly jurisdiction in our country, I'm not sure they picked the right venues to bring these lawsuits. And so, if they're in federal court in states like New York and stuff, which are not that friendly to policyholder claims, I think the insurance company's position and arguments are going to be stronger and more likely to prevail. And so I think the answer is going to be a lot of it depends on where these lawsuits are brought, whether they're in state court or federal court, and in which states. Some states are not friendly to claimants, and some states are. And I'm not sure how much energy was spent by the plaintiffs' bar before they brought these lawsuits, thinking about which state and which court would be the best to bring them in. So I can't handicap them as a whole at this point, but I would say it's going to depend a lot upon those two factors, whether you're in federal court or state court and which state you're in, because these claims are all driven by state law. And the law varies a little bit from state to state on how they interpret policies, but it also varies a lot on the judicial leanings of the judges. So states that are more conservative tend to read these policies more literally, like they don't care about the public policy arguments I just mentioned, for example. They're going to look at the language and say, do we think this covers these claims or doesn't it? And they're not going to listen to these public policy arguments, and they're not going to be as persuaded by the lack of a virus exclusion argument, because they're going to say, well, it doesn't matter if there's a virus exclusion. I'm just reading the words on the page here, and if I don't think it covers this stuff, then it doesn't. And so it's going to depend a lot on that, just the background and the inclinations of the judges deciding them.
And when we see these types of big kind of events, like we were saying, asbestos, CERCLA, and now COVID, they kind of get grouped together into those specific events. Do you think that any of the previous decisions from asbestos litigation and or CERCLA litigation would be applicable in this particular situation?
Yeah, I think a lot of that case law, that body of law that was developed because of asbestos claims and environmental claims, they are going to be the first sources that the courts are looking to, because a lot of these issues are going to overlap. For example, you're going to have an argument there's sort of a continuous injury occurring as long as you're shut down. There's like a new injury occurring like daily, monthly, you're still out of business. They're going to look to the case law from the environmental and asbestos context on how they're supposed to deal with that issue, where you have an injury that's spread over time. It's not just a discrete event. They're going to look at whether or not the contamination, like with asbestos and stuff, can translate into the same situation with COVID-19. So I think that the starting point for a lot of courts will be the case law that developed relating to asbestos environmental claims will be the starting point for their analysis.
And both of those types of claims, the asbestos and CERCLA, I mean, they cost, just in fees alone, billions and billions of dollars to litigate. Do you think that this, from a business side of things, and I guess as for an insurance company, I mean, an insurance company is a business, do you think it's worth litigating these claims?
These are bet the company lawsuits, literally, for both sides. I mean, if you believe the insurance industry, they would say if we had to pay a lot of these, or many of them, we're going to be bankrupted. I don't think it's as dire for the insurance companies, because they'd have to lose lots and lots of these cases before they'd really be in jeopardy of going bankrupt. But for the claimants, these small restaurants, these beauty salons, these businesses that are being shut down for 2 or 3 months, if they can't recover under the insurance policy for that, or they don't get a government bailout, one or the other, most of those companies will never come back. And so if your choice is just going bankrupt and going out of business forever, or soon to try to win, I can see why the calculation would be for a lot of them that it's worth rolling the dice on trying to recover, because if we don't, we're just out of business, period. People shouldn't overestimate, by the way, the hope for bailouts. I was just looking at some stats the other day on flood claims, for example. They're currently projecting there's roughly $20 billion a year in America of losses related to floods. And of that, about 16% of it is paid by government bailouts, and maybe 20% or so is paid by the flood insurance program, leaving 2/3 of those losses as uninsured. So if people are hoping for a bailout, government bailout, they may be disappointed, because they have not covered the slack in the hurricane and flood context, despite the billions of dollars we hear being paid by the government for the victims of floods and hurricanes and stuff. It's usually far short of what they need to be made whole. So if people are counting on a bailout for these pandemic COVID-19 business interruption claims, I think a lot of them are going to be disappointed by what they receive.
And one more kind of insurance topic, just really quick. I'm not sure if you've done any research on it or not. I thought about this question this morning. But if these insurance companies in certain jurisdictions, let's say, do have to pay out these claims, do you think that they're going to be able to sue someone else in subrogation to reclaim that money at all?
They might be able to try. I mean, they almost all these insurance companies we're talking about will have reinsurance, which we haven't discussed at all today. But that's basically an insurance company has insurance. Another insurance company provides them insurance for the claims they have to pay. So most of these insurance companies are going to have reinsurance. So they're going to be able to spread these losses if they have to pay them to other companies, most of which are set over in Europe and in Bermuda and stuff. So a lot of them are not American companies, these reinsurers. So they're going to be able to spread some of those losses to them. But back to your specific question about subrogation, I think they'll try. I mean, I think that's one of the reasons where you're seeing talk about legislation being passed right now to give businesses immunity for if they're opening up and they're running the businesses, they can't be held liable for people getting sick there. If you don't have legislation like that, I do think insurance companies will try subrogation claims by saying, the only reason, it's going to be trickier on the business interruption side, but if they had individual people getting sick that they were liable for, people coming to your business and getting sick, and you turn in an insurance claim, the insurance company will probably try to have some subrogation claim against somebody else, claim they brought the disease into the business, that kind of thing. But on the business interruption claim, I guess you'd have to be looking at the government to be the person they go after for the subrogation. I haven't thought about that, about whether they'd have immunity or whether there'd even be potential liability there.
Mm-hmm, mm-hmm. All right. Well, that's all I have to ask you. Is there anything else that you wanted to put on the record for listeners?
Well, I don't think so. I think that pretty much covers that. I guess there is one other argument that I didn't mention, which is this idea that whether or not prophylactic measures like these government orders shutting down businesses before there's any evidence that there's contamination at the business or that anybody at that business has COVID-19. I do think there's an argument related to that, which is that, a stitch in time saves 9, so to speak, that we're better off preventing injuries from occurring before they occur. And so, the insurance industry is going to say, until the injury occurs, we don't have any liability for it. But there is an argument that, the costs associated with preventing injuries should be covered under insurance policies as well. And there are some cases that say that in the context of building collapses, the building's gonna be covered if it collapses, but there's cases saying that if you prevent the building from collapsing, you should be able to recover the cost of that. And insurance companies have provisions in their policies that are similar to that as well. They have what we call sue and labor clauses, which essentially just says the cost you incur trying to prevent damage that would be insured under the policy, we'll cover that because we want to incentivize you to minimize the damage. The difference is, of course, that the losses already started to occur before those provisions kick in. And the question is whether or not you should be able to get coverage for preventing injuries before the loss even occurs. So by shutting down your business before you actually have people getting sick, should that be covered or not? So I think from a public policy perspective, it makes sense. You'd rather have people preventing injuries rather than waiting for them to happen and then turning the bill to the insurance company. So that's the only other thing I guess I would add to the discussion.
All right. Awesome. Well, thank you so much for taking the time to speak with us today. It was very informative. And we appreciate you being here.
That's always my pleasure, Amber.
So that is it for today, folks. Thank you again to Professor French for joining us today. If you are interested in reading more from Professor French, please be sure to check out the links below in the episode description. And until next time, have a wonderful week.